The Bobby O Show.
Welcome to the Bobby O Show. This is Bob O'Potzner, and I got a great show for you. But before I start the show, I just would be remiss if I didn't mention that the D on my tie stands for Duke. Final Four coming up this weekend. Those of you watching the show next week on remote or on tape delay will have known the result. But right now we're all jittery, and I'm sure every one of my guests and my director are rooting very strongly and fiercely for the Duke Blue Devils for the national championship. Right, guys? And on that note, I will introduce for you today Rosemarie Ferrante and Jennifer Champagne.
Hi, Bob.
Hi, guys.
Hi, Bob.
How are you? I'm sure I got it right who you're rooting for in the Final Four, since you are all Duke fans for the next half hour anyway. I have a great show today because of a lot of reasons, and mostly because of the guests. Both guests have been on my show before, and this show's going to be talking about the divorce process. And we have done shows in the past talking about the different methodologies for divorce. And these two ladies are heavily involved in the non-adversarial divorce process, as am I, but not nearly as much as they are, because they're both former presidents, or one is a current president, Rosemarie, and Jennifer's a former president of CCND, which they'll both talk about a little bit. We're going to talk a little bit about the process, and we're going to give a couple of different examples of how, in reality, on two different topics, the non-adversarial divorce would work. And we're trying to educate people on how to do a divorce process in which it's not going to cause a situation for the rest of your lives, if you have kids especially, that you're going to have scars from the divorce process. And to that note, I will introduce the two ladies and ask Rosemarie just briefly a brief background about yourself, and then I'll do the same for Jennifer.
Sure. Thank you. So as you said, my name is Rosemarie Ferrante. I'm a family lawyer in Connecticut. I've been practicing exclusively family law for over 25 years, and my practice is solely dedicated to divorce mediation and the collaborative divorce process, which, as Bob mentioned, are the non-adversarial divorce process is different than traditional litigation. And I am currently the president of the Connecticut Council for Non-Adversarial Divorce. We are the statewide professional organization for family mediators and collaborative divorce professionals in Connecticut.
Thank you very much. Jennifer?
Thank you, Bob. I am a therapist. I am in private practice. I have offices in Shotland and in Madison, and I have been in practice for upwards of 35 years, and I work exclusively with parents and families who are either in the midst of a divorce process or are now divorced and having a difficult time managing the intricacies of a two-home household. I also practice in the collaborative model. I am the past president of CCND and currently an adjunct at Quinnipiac Law School.
I do both collaborative and I do the traditional litigation model. And we're going to talk a little bit about the differences that exist between those two models. But I want to just read for you a very brief opening from the CCND, which I did my homework, ladies, preparing for today's show. And I think the opening part of the website is very pithy because it talks about managing your divorce through collaboration. We're going to focus mostly today about collaborative law, more so than mediation. But the opening of the website says, you and your spouse can successfully end your marriage without litigation if you have the same goal in mind: divorcing without further emotional and financial damage and staying out of the courtroom. Non-adversarial divorce includes the collaborative process and mediation, both of which are designed to keep you out of court. Our members are trained to focus you and your spouse on the issues, and that's the whole theme about the collaborative. And the lawyers involved, the mental professionals involved, and the financial people involved are trained not just initially, but over time. In fact, I'll be going to a seminar, if all goes well, on May 16th, which we're going to talk about in a little bit, offered by CCND at Quinnipiac University, to help us continue daily learning about the collaborative process. And maybe Rosemarie, you might talk a little bit about the training that goes into being a collaborative attorney or mental health professional as a sort of opening salvo today.
Sure. So yeah, as you had mentioned, Bob, CCND's mission is to promote dignified and respectful private practices through mediation and collaborative. And so for both of those options, there's three main components. Well, I guess I should say it differently. We have three main industries and disciplines that are trained in mediation collaborative. So it's not only legal professionals, it's mental health professionals like Jen and financial professionals as well. And our organization vets and has not only the basic trainings that are required for membership and for mediation and collaborative divorce professionals, but also advanced trainings. And in this meeting today, in this chat today, we're going to be talking about power imbalances, so we can circle back to our upcoming training. But yeah, the training is really about conflict resolution. The training is about therapy and how we help children's voice be heard in these processes. The training is about conflict resolution. And so many of us lawyers are trained, obviously, in advocating zealously for our clients. But when we're representing clients in a collaborative divorce process, it's a very different process.
And since I do both at this point in time, I will agree with Rosemarie very much. And even though 90% of all divorce cases settle anyway, there's a different, in my opinion, and I think Rosemarie and Jennifer would agree, there's a different mental set in the divorce process. Typically speaking, in the non-adversarial process of a collaborative, for example, we'll be in my office or someone else's office, and we'll take turns in the office, and it'll be four of us in a conference room, the two parties and the two lawyers, and then some of the coaches and other people we'll talk about in a moment. But it's all in an office situation. It's not being in the courthouse, which is courthouses, no matter how we try, are cold places, and it's a place you don't really want to be in. And so, Jennifer, you might talk a little bit about, from a mental health perspective, what it means to a person to, let's say, be in a courtroom versus in an office, and how it might change the frame of reference of the participants and the lawyers. Because I will say that we do treat issues that come up, like the two we're going to talk about today, differently in the litigation model and the collaborative model.
Sure. When we're talking about a traditional litigation model, it's a very linear path. The parents are represented and they are moving forward based on a goal that they will have personally. And we tend to see more of a win-lose mentality when it comes to moving forward in what we call that traditional setting. When we're talking about collaborative, first of all, it's important to remember that in a divorce, there are three elements to the divorce. There's the legal piece of it, there's the family, the emotional, and the parenting piece, and there's the financial piece. So when we're approaching it in our offices, sitting around a table with parents, it's very goal and interest driven. And the goal and interests are for not just the individual parties, but the family as a whole. So when we are talking about what parents have as goals and interests for themselves and goals and interests for their children, it becomes more of a holistic approach as we are looking to set everybody up for success as they become the act of being divorced. Because we as professionals know we're going through getting them divorced, but then once that is over, they have to live being divorced. So the collaborative process has more of a hands-on piece with the three professionals, financial, mental health, and legal, in preparing our clients and helping them towards that place of being divorced.
Jennifer and I were involved in a very difficult case in which the parties had lost a child. And it was a very sad situation. The other attorney and I decided we needed someone to start from day one to help us, because we figured we couldn't handle that. We as professional attorneys, we're not mental health professionals, although we are, shall we say, amateur psychologists, which we really are not. And if we had done that case as the traditional model, it would have been a real problem. But having the meetings in an office, and Jennifer often brings her clementine oranges and whatever else she likes, and it makes it a much friendly attitude. But the law still is relevant, but you do it in a much calmer way. Rosemarie, can you talk a little bit about the other people other than lawyers who are typically involved in the collaborative process? And then from there, we'll segue into the two examples we want to talk about today.
Sure. Yeah, so as Jennifer had said, it's a team approach and it's interdisciplinary. So in addition to the two lawyers who are there on behalf of both spouses, there's the mental health neutral and the financial neutral. And so the interdisciplinary team, as Jen said, really supports all three pieces of the divorce: the emotional piece, the financial, and the legal. And frankly, the legal is a lot smoother when people have the support they need emotionally and financially. Because through this process, we want to make sure that people are making good decisions, not only for themselves, but for the entire family unit. As Jen said, it's a very holistic look at the family and how we can set them up for success in their post-divorce life. We, in a litigation, and just one of the things to think about is, a litigation will get you to an end and get you to a final judgment, but the collaborative process is much more in tune with ensuring that the family is set up for success as best they can be given their particular circumstances.
Yes, and so having said that, let's talk a little bit about a couple of models that we want to, or examples we want to talk about, and how it would be done in the non-adversarial process, and maybe how it would be done differently if we did it in a litigation traditional model. And by the way, Rosemarie also used to do divorces in the traditional model, and she and I have both, especially Rosemarie much more than I, but we've found this is a better way to do it, is the collaborative process. So let's talk a little bit about one example we're going to discuss today is the issue of power imbalance. What do you do when you have a situation where, and it comes up in cases, where one side or the other has different power imbalance? And perhaps, Jennifer, you might talk a little bit about what would categorize itself as being a power imbalance. And then Rosemarie and I will mention that a little bit. So how do you define when there might be a power imbalance?
So power imbalance could have quite a lot of definitions. When we think of power imbalance, it could be as difficult, complicated, and scary as very intense and difficult coercive control and domestic violence situations. On the other end of the continuum, it could also be a power imbalance, but one in which it had been a situation in which perhaps one party managed the finances and the other party had very limited understanding of what those had been. So when we talk about power imbalance, we don't always know right from the beginning exactly how detailed it is, which is why it becomes incredibly important for us as professionals to spend some time doing an intake process and screening it, for suitability. Once we determine initially if it is going to be suitable, meaning that it's not going to be dangerous for anybody to participate in that way. Just because there is a power imbalance does not always negate it from the value of a collaborative process. If it is a situation in which one party is simply unaware, or one parent had not been involved, or one parent had not been educated about their finances, the collaborative process would allow a great deal of education and information so that that person would be in a position of learning about their finances, being able to make some good decisions and supported, and then have the tools that they would need to start managing their own financial picture on their own once that divorce happened.
Rosemarie, if you had a situation, and Jennifer mentioned different types of power imbalances that could exist, how would it be different how you would approach a collaborative matter in which the power imbalance were one in which it was the emotional intimidation versus the financial control, which could be combined? It could be those could be combined. If it's a physical intimidation, it becomes an issue whether or not you want to have people, if there's a restraining order, you couldn't have them in an office together. But so let's deal with the emotional imbalance of power and the financial. Would you treat it differently? And if so, how might you approach your collaborative matter differently for those kinds of cases?
Yeah. So again, the range of power imbalances can be from just different roles in a marriage, leading one spouse to not have all of the financial information or education needed to make good decisions. And in those circumstances, we're really relying heavily on the financial neutral to be able to assist in ensuring that that spouse has the information they need to make good decisions throughout the process. When we get to situations where there's emotional power imbalances, which again can range from behaviors to full on coercive control, we as professionals need to really understand and to be trained on assessing and to keeping that communication open within our team, because the attorneys are going to rely very heavily on the neutrals and the mental health neutral in particular in those situations to guide the discussions, to continuously throughout the process discuss whether this is the appropriate process and how we can ensure that everybody's needs are met throughout the process. So it's a very, we're heavily relying on the neutrals in these circumstances to really be able to guide both spouses. Number one, ensuring that safety is first and foremost ensured, and B, then again, guiding discussions in appropriate manners so as to make sure everybody is able to make good decisions throughout this process for the children, for themselves, for their finances, etc.
And not only is the information important, that let's suppose there's one party who does not have all the financial information. It's not only getting information, it's also understanding the information. I had a case one time that was collaborative in which one of the parties had very serious disability issues, and her life expectancy was not going to be that great in terms of duration. So we brought in a neutral who was a trust and estate expert to explain how trusts might work and explain it. So it wasn't a matter of being difficult, but rather we had this neutral that all of us heard at the same time explaining how different trusts might work and how you might protect assets for the family unit if you put some monies for the disabled spouse into a trust versus having it handed outright, which might have impacted negatively the ability to get funds from the federal government and the state. So we as lawyers and the mental health professional and the financial people often will bring in other kinds of experts to help us deal with the difficult situation in that regard. Any comments, ladies?
The position of having neutrals in these type of delicate situations allows for a central repository. Bob, you talked about, everybody learning from the trust professional at the same time. When you have a mental health professional who can really tend to the overall moving forward in a safe and healthy manner of the whole family, when you can have a financial neutral who can then gather all of the information in one place with transparency and education, it creates an atmosphere between all of the parties in which everybody feels a good understanding of what it is that they're managing, what it is that they're looking at, whether it be children, money, whatever the topic is, and having those tools that they need. It is about building that toolkit for our clients.
And also economically, if each lawyer is going to have, or each party is going to have the traditional model, so to speak. And by the way, if you have the traditional model, you could still have one expert for both, but it's just less common. But if we had brought in, each of us had hired a trusted estates attorney, I would have heard from one, they'd heard from another, and then there'd be a perhaps discussion between the two of them, the two experts. Whereas if you have one person who the lawyers and the mental professional, et cetera, agree upon, then step one is there's trust. I had a case recently where we all used in a pension case, Betsy McMahon, who we all know in the divorce field, is the person to write qualified domestic relations orders. By having her for both attorneys, it was economically efficient. And by the way, typically speaking, I believe, I think Rosemarie would agree with me, that collaborative is typically more expensive less expensive on average than the traditional model, which is more expensive. Do you agree with me on that, Rosemarie?
Absolutely. And I think the efficiency that you mentioned is just so important because with the team, and with these private meetings and with the ability for the neutrals to work with the clients, without the attorneys there, whether it's to have discussions regarding parenting plans or whether it's with respect to gathering the financials. We have a process in place to bring people from point A to point B to point C that's private, that's fully transparent. Again, having a conversation with their CPA as opposed to dueling CPAs in a litigation and waiting on court dates is a much more efficient process. And therefore, it is typically less expensive and typically takes less time than a traditional litigation.
And also, we didn't mention today, but we have in past shows, there's always a collaborative agreement that's in place. And it's also states in the agreement that it's a confidential arrangement whereby if the collaborative process falls apart, nothing in the process that was exchanged or talked about, unless parties mutually agree upon it, doesn't get before the court, which I think is very important. Another thing before we leave this topic is I find difficult cases sometimes when you have in those unique cases where there is the emotional control situation problem. Sometimes a spouse who feels emotionally on the downside of things wants to have the lawyer be a quote bodyguard unquote. And so let's say they're married for 20 years, and for 20 years is one party. Let's say the husband in this situation, hypothetical, has been abused emotionally by the wife. Now's my chance to have Bobby O or Rosemarie or another lawyer fight hard for me. And I would like to have either lady comment, either expert comment about what do you do in those situations where you can feel that the client you have, that I have, wants the quote bodyguard unquote. Give me help on that. Jennifer, start.
Well, certainly as the mental health, I'm less in the position of that bodyguard. However, what I do often see as far as what they're looking from me is some sense of trying to have the other person take responsibility or recognize where they've done something that hasn't been best for the other parent. So that becomes a dynamic in the room as we are trying to work through that as to what it is that one or both party is trying to accomplish. Sometimes people just want to be heard when it is a little bit less complex, when it might be as difficult as a severe domestic violence situation. Obviously, that's a different story. But oftentimes, many times people want to be heard because they were misunderstood during the marriage. And so part of this is whether or not there's place for that, for people to understand and identify that and how that helps them move forward.
And by the way, it's not unusual in collaborative process for the lawyers and to say, why don't you, we call them coaches, why don't you, Jennifer, as the coach, mental health coach, why don't you meet with the parties a few times without the lawyers present to resolve the custody and visitation issues? Rosemarie, do you have any comments on what I was saying before?
Well, a little comment on what Jen was saying, because I think it's important for people to know, many people feel they want an attorney in the room at these meetings, and many people opt for collaborative over mediation for that reason. But it's important for the people to understand as we're discussing the process with them and assessing whether it's the right process for them, that their lawyer isn't there to be their bodyguard. Their lawyer should not be seen as their spouse's adversary. This is a very different process because the conversations are going to be more like mediation conversations than litigation. The lawyers in a collaborative aren't there to, pound their fists on the table and make demands. They're there to really ensure that their client's goals are expressed appropriately and that their client is open to understanding their spouse's goals and looking at the goals of the entire family to come up with plans that are going to meet their goals. Like Jen started in this whole conversation, this isn't a win-lose. This is a win-win as best it can be, given, again, the circumstances. Divorce isn't easy. These conversations are very difficult. And again, the role of the neutrals is really important to keep people in that mindset because sometimes the lawyers slip up. Jen's seen this often. And that's really the roles of the beauty of this process is the neutrals are there to keep everybody focused again on the family as a whole.
We have about 4 minutes left. I want to go to the next topic. I had a case a little bit ago in which there was an issue of substance abuse. In that case, it was alcohol abuse. And it was not collaborative. It was the traditional model. And in that situation, it was a very difficult matter. We ended up resolving it ultimately, but it was very tough because I had to say to the party who was not the drinking party, I'd have to allegation, say, hey, this is what you did with the child this time and that time, and it became very adversarial. He walked out one time, etc. I'd like to have both of you talk, and I'll go to Rosemarie first, talk about how do you try to handle in the collaborative process of the situation where there is an abuse problem?
Mm-hmm. So when there's substance abuse, again, we really need to talk to and ensure that the mental health professionals, the mental health neutrals are guiding these discussions. What's appropriate, what's safe, what makes the most sense. There's many tools that we might use and bring into the process to ensure that drinking isn't occurring in front of the children, or certainly not during their parenting time. But it's again ensuring that the parenting plan is safe, is ensuring that everybody is safe first and foremost.
I have in that case we used Steve Paymer, who was an expert in abuse issues, and it was very helpful because there's machines and things you can do to test if someone's drinking. But Jennifer, we have a couple minutes left, and I want to leave a little bit of time for Rosemarie to talk about the conference coming up. Any thoughts you have on how you approach situations where you know there's a drinking problem and we're trying to help resolve it, but if you make the person who's a drinker feel badly or guilty, that's not going to work. So what do you have for thoughts, Jennifer?
So following up to what Rosemarie was saying, because it's for the good of the family, there's an opportunity for us to really be able to work together to try to identify if help can be managed and do so in a supportive way, rather than a way in which somebody really feels attacked or minimized.
Back to Rosemarie real quickly before we get to Rosemarie. I want to say I appreciate what you guys have done very much. And part of having a good show is to have you want to come back for more. So there's more we want to talk about together. Real briefly, Rosemarie, what's the conference about?
So on May 16th, CCND's conference this year is focused on understanding, assessing, and planning for power imbalances, coercive control, and abusive behaviors in divorce. It is open to members and non-members, so you can go to our website for more information, which is gooddivorcect.com.
Thank you both. You guys are both great professionals. I've always enjoyed working with you, even when we disagree, even when you think I'm wrong, which is impossible, right? But this has been Bob Pottsner. We'll have you back again if you won't mind coming back. This has been Bob Pottsner on The Bobby O Show. Remember these 3 words. Let's go, Duke. Have a good day.